our guest of honor, Mr. Prabhuling K. Navadgi, Advocate General of Karnataka, to address the gathering. So please.
My respectful pranams to Honorable Justice M. N. Venkatachalaya, former Chief Justice of India, who has just delivered the prefatory address. Honorable Shri Justice Abhay Srinivas Oak, Judge Supreme Court of India. Honorable Shri Justice Alok Aradhya, Acting Chief Justice of the High Court of Karnataka. Honorable Justice Veerappa and Honorable Justice P.S. Dinesh Kumar, Honorable Judges of the Karnataka High Court. The Principal of the KLE Society Law College, Shri J.M. Mallikarjunaya. The Member Secretary of Samyukta Trust, Shri Sridhar Prabhu. All the Honorable Judges of the High Court who are present in the hall. The Additional Solicitor General of India, Shri Nargund. My colleagues, Shri Shanti Bhushan and Mr. Arun Sham. Members of the District Judiciary are here, the Law Secretaries here, Mr. Mantish Kautigamai, all the law students, distinguished invitees, ladies and gentlemen. Well, I must say, the organizers have put me in some predicament. They have asked me to speak after the address of Justice M. N. Venkatachalaya and before this battery of judges led by Justice O. are to speak on a subject which they are the best to speak. So the situation and the propriety demands that I keep it as brief as possible. We are all here to hear the inaugural address of Justice Oak, and I'm sure it would be a very illuminating one, throwing some light on this very unique and interesting subject. I must compliment, of course, the KLE Society as well as the Trust, Samyukta Trust, for organizing this very unique topic, I will say, on the National Colloquium on judiciary opportunities and challenges. Of course, it's a very vast subject. It requires a tremendous amount of understanding, and this is not a subject very often visited. We have seen topics, discussions on legal education, legal profession, speedy justice, but judiciary as a career and its opportunities and challenges are something which is very unique, and I'm very sure at the end of this colloquium, we'll all go enriched with the experience being shared by all honorable judges. But I did feel it necessary to share with this very august audience some of the sub-classifications or topics which could be part of this national colloquium. When I did list out, this is what I felt. Judiciary opportunities and challenges would include, according to me, the problem of judge population ratio, which we are facing today, the service conditions of judiciary, digitization of judiciary and its challenges, the need of an adequate training institutions at the pre-recruitment stage as well as at a stage where judges are actually recruited, the alternative dispute resolution system as a robust model, the alternative dispute resolution system as a wing of judiciary, inculcation of the Bangalore principles of judicial conduct, the need to give speedy, effective justice, judgments to be delivered both by the subordinate and the High Court, which could be understood by the common man in their own language. These could be some of the subjects which we should all think and ponder over, is my firm belief. Well, I must also begin by saying, when we speak of judiciary, particularly to all my younger friends, I'm reminded of what Honorable Justice Ratnavelu Pandian, in his own inimitable style, said in S.P. Gupta's case. He opened the judgment by stating so, and I quote, "Solomon's throne was supported by lions on both sides. Let them be lions, but yet lions under the throne, being circumspect that they do not check or oppose any points of sovereignty." he likened Justice Ratnavelu Pandian, Solomon throne to be to that of judiciary, with the two lions being legislature and executive. And I hope this symbolism will continue forever. And for all my younger friends who aspire and wish to become judges, must always remember that the Solomon's throne has been likened to judiciary, with both lions under the Solomon's throne being legislature and executive. He says, being circumspect that they do not check or oppose any points of sovereignty. I also want to share with this very august audience 2 or 3 views which I feel are apt for the present colloquium. Number 1, when we speak of judiciary opportunities and challenges, we must understand the fine balance the Constitution has demarcated between higher judiciary and subordinate judiciary. Whereas Article 233 deals with subordinate judiciary, Article 213 onwards deals with higher judiciary. I am of the view that the subordinate judiciary particularly, which is the first point of contact to a common man, plays a very decisive role in not only keeping the rule of law, but also ensuring that common man's faith in judiciary is kept intact. Therefore, the service conditions of subordinate judiciary, in particular, I feel, I'm a great proponent of it, must be commensurate with the great stress and strain the subordinate judiciary undergoes. I'm very glad that the successive judicial pay commissions have kept this in mind and have always augured well for by increasing the remuneration, and the governments, of course, have accepted the same. The Constitution Bench of the Supreme Court in Anita Kushwa versus Pushpa Sudan identified 4 aspects that constitute the essence of access to justice. These were: the state must provide an efficient, effective adjudicatory mechanism. The mechanism so provided must be reasonably accessible in terms of distance. The process of adjudication must be speedy, and the litigant's access to process must be affordable. It has been universally now, of course, recognized and reiterated more than once that the timely, justice, and speedy trial is a facet of the right to life under our Constitution. Therefore, these are the 2 aspects which we must always keep in mind. Firstly, access to justice must be made affordable, easy, and that speedy justice becomes part of Article 21. One other aspect I must mention with the kind of figures we have today is about the problem of judge population ratio. In All India Judges Association and Others versus Union of India, while endorsing the views of the 120th Law Commission of India report, the Honorable Supreme Court directed that the judge population ratio in India must be 50 judges per million of population, and that the norm be achieved within a period of 5 years from the date of order, not later than 10 years in any case. The Justice Malimat Committee report on reforms in criminal justice system also commented upon the gross inadequacy of the judges' strength at all levels. The Honorable Chief Justice of India, N.V. Ramana, has called for measures to improve the judge to population ratio. At present, India has a sanctioned strength of 25,628 judges. This is when over 4.7 crore cases are pending in courts across the country. In 2016, total strength of judges in subordinate judiciary was 20,174, and it was expected to be around 35,155 by 2019. By 2040, it is estimated that there is a need for increasing the number of judges to 75,595, with average of appointment of 2,075 judges every year. So you could see the demand for an effective, qualitative judiciary is much more relevant than any other time. I must conclude by stating, of course, that the topic, of course, they have said that judiciary as a career. But I must share, particularly with all my younger friends, as to in some way, though in the modern day language it is right, but according to me, it is a misnomer. Because joining judiciary, according to me, is the greatest, I will say, as in Kannada we say, samarpane, dedication to oneself to the nation itself. So it's just not a mere career, but you give yourselves to the service to the nation. I must end by quoting Benjamin Cardozo when he says how judges decide their cases, which is in his very famous article, The Judicial Process. This is what he says: there is in each of us a stream of tendency, whether you choose to call it philosophy or not, which gives coherence and direction to thought and action. Judges cannot escape that current any more than other mortals. All their lives' forces, which they do not recognize and cannot name, have been tugging on at them. Inherited instincts, traditional beliefs, acquired convictions, and the resultant is an outlook on life, a conception of social needs, a sense, in James' phrase, of the total push and pressure of the cosmos, which, when reasons are nicely balanced, must determine where choice shall follow. While complimenting the Trust and the college once again for organizing this colloquium, I thank them for giving me an opportunity to be in the midst of all of you today, and wishing each one of you all the very best. Thank you so much.